context of an election, that jurisdiction is completely ousted by Article 225 of the Constitution and the judgments of your lordship. Your lordships have said no election will be called in question. The meaning under Article 225 of the Constitution, and your lordships have said in Javed Hashmi's case that election starts from the time the Election Commission notifies the schedule till such time that the candidate is declared, returned or elected. The decisions of the election tribunal, your lordship has said, in Raza Hayat case cannot be called in question even in a writ petition.
Prior decree B cannot be used.
Could not come, she just arrived.
Suppose there is a prior decree before the start of elections that cannot be used in the...
My lord, the prior decree will only say whether I have paid my debt or not. Now, in that case, as my lord, Mr. Justice Yahya Afridi identified, there will be a disqualification attracted under Article 63 of the Constitution. No declaration under Article 62 of sagaciousness or righteousness. My lord, which your lordships, with your vast experience in civil law, which civil court, when passing a decree, even in a banking suit, and says this money is outstanding, then goes on further to declare that this person has ceased to be sagacious, right?
That's the question. Can you just go back, Mr. Madhu? We cannot attribute redundancy to the Constitution, even though it's quite clear that there's no such declaration that can come from any court. But we have to give meaning to the, because we can't just throw it out. So, making an effort to giving it a meaning, this paragraph is crucial in Samullah, that the declaration they're talking about is arising out of civil jurisdiction, inter-party litigation. So, for example, there's a case where a sale deed has been struck down as being fraudulent or forged. Now, there it has been, as a consequence, we understand that that person has committed fraud because he came up with a fraudulent sale deed. That is a bit of a construction that we have to do just in order to justify this declaration given as a court. Having said that, all the other declarations which are coming in through original jurisdiction and the writ jurisdiction not arising from civil jurisdiction are out of the canvas, right? So let's first specify that the declaration we're talking about is inter-parties arising out of civil litigation. Now, in the absence of 232, we would have had to construct what is to be done. I'm just saying that legislation could, not justifying 232, but legislation could say that for the purpose of election, such a civil, such a decree which is arising out of civil litigation could have a time frame for purposes of election. So the question is, can legislation put a time frame on this declaration? Could that be possible? Not the way it's worded in 232. My question to you is that
all the cases together.
First of all, Sabiullah Baloch helps us identify that which declaratory decrees we talk about, which declarations are relevant. Declarations arising out of civil jurisdiction, which are inter-parties. Number one. Now, could legislation, not the way it is done today, but could legislation say that this declaration will continue forever for between the parties, but for the purposes of election will have a time frame? Such a legislation is not the way it is done now in 232, but could such a legislation be possible to say that a declaration inter-parties arising out of civil litigation for the purposes of election would only be for 5 years, even though between the parties it will remain forever till it is set aside, but for the purpose of election? Could such legislation take place?
My lord, that was a bit later, but may address it right now.
We've heard that point.
My lord, when your lordship looks at 62(1)(f), the constitution makers under the 18th Amendment do not say that this is a declaration of a civil court. They say,
My lord, I have
no declaration to the contrary by a court of law. A criminal court is as much a court of law as a civil court. Now, if your lordship reads a court of law as a court of law, a court of plenary jurisdiction, that would include courts both on the civil and criminal side which decide cases after recording of evidence. And in that, if your lordship does that, then 63 and 62 will have to be read together. There's no way one can read them differently. My lord, may I just preface this a little further? Sure. My lord, a question has been asked repeatedly, and my lord, Mr. Yahya Afridi asked that again yesterday.
Outside section.
Why have two lists? Justice Hilali asked the same question again. Why have two lists? What's the difference? My lord, the two lists made perfect sense under the original 1973 Constitution. The list of qualifications was that you should be a citizen of Pakistan. For MNAs, you should be 25 years of age. For senators, you should be 30 years of age. And that is where the qualifications ended. All three were qualifications. The disqualifications were that he is of unsound mind, that he is an undischarged insolvent, or he ceases to be a citizen of Pakistan or acquires the citizenship of a foreign country. When your lordship looks at them, there is no disconnect. The qualifications are separate, the disqualifications are separate, so there is a disconnect. They deal with two different subjects. One where a qualification is acquired, one where a qualification is lost in a way, or a disqualification occurs because the person loses sanity, or the person loses citizenship, or a person becomes an undischarged insolvent. The moment the court declares that person as insolvent, then the disqualification is removed. The moment there is a declaration that the person is of sane mind, the disqualification is again removed. The moment the person acquires the citizenship of Pakistan or sheds his foreign citizenship, the disqualification is again removed. The disqualification
is 62. Article 62 applies pre-election, post-election, or at any time.
My lord, the way I look at it, election 63 applies at any time. Yes. 62 applies only at the time of election, because he shall not be qualified to be elected or chosen as a member of Majlis Shura.
At the time of filing nomination,
yes,
my lord, and the person files his nomination and his opposer submits some document before the returning officer that something legally has been passed against him, so he is not eligible to contest the election. Is it your meaning?
My lord,
by the declaration of law, because opposer can file the application, his nomination form should not be accepted because he is not eligible to contest the election.
My lord, yes.
What is the main interpretation of Article 62, whether it applies at any time, it applies before the election, or any time after election?
My lord, 60, when your lordship looks at 62 and 63 and reads them together, because that's where I was coming to. After 1985,
what is the difference between the opening language? The person shall not be qualified to be elected, and if you look to 63, a person shall be disqualified from being elected. There must be some distinction between the framers of the Constitution.
If I may interject, Mr. Abdul Malik Khan, and it may help you to respond to my lord as well. Somehow, as I see it, we've got bogged down in restricting
in this case was following the Supreme Court
ourselves to reading just a particular provision of the Constitution. And we seem to have forgotten the Constitution as a whole. What is the Constitution all about? What does it do? What are the fundamental rights? Article 17, the High Courts are bound by judgments of the Supreme Court. And we are going to a particular provision of the Constitution and just reading those and disregarding everything else. We're disregarding the history of Pakistan. We're disregarding the constitutional history of Pakistan in particular. We're disregarding the fact why these amendments were brought into the Constitution. We're disregarding the fact that original Constitution has a greater sanctity than amendments brought there too, unless there are such amendments which enable to serve the people better. For instance, Article 19A, Article 10A. Now, nobody can say that these insertions have taken away something from the people of Pakistan. Rather, they have given something to the people of Pakistan, including Article 25A, compulsory education up to the age of 16. And these are on the contrary, an insertion into the Constitution, and there has not been one insertion. They start with General Ayub Khan, and successively more and more encroachment into who I will determine will be fit to govern Pakistan. First of all, the initial question will arise, who am I to determine this? Why can't the people of Pakistan themselves determine? So what? Disregard how it came into the Constitution. Now you're stuck with the language of the Constitution. At least I am not persuaded to adopt that approach. I cannot forget the history of Pakistan, and unless you can say they are very beneficial things, we had given public notice in prominent newspapers. Not a single political party has come before us which has said, leave alone those who are not even in Parliament, said that this is a good interpretation of the Constitution. So then we come into, there is another aspect which I consider. There are things which are specifically mentioned. If, for instance, for theft, you mention a particular sentence, and if you say for a traffic offence or for some other offence, there may be punishment. But for instance, the legislature forgets to mention for what duration. You can't possibly say,
declaration means for all such type
I'll
of
impose a punishment for murder. There must be some logic, there must be some reasoning. The reasoning is to destroy Pakistan, that's fine. You can contest elections for 5 years. But if you make a single mistake in the nomination paper, you're disqualified for life. Now, we are just stuck with the wording of it. Have you lost all logic and sensibilities?
And after recording evidence or without recording evidence?
Why are we not? Nobody is addressing that. I keep requesting that to be addressed, but we're just bogged down by the 62(1)(f), and the whole of Pakistan, because the general decided to impose that, has now got us thinking. Leave aside the Constitution of Pakistan, we're just stuck with his language. So, can you just explain? What I really wanted from you as a constitutional expert was to expand the vision and not restrict it. And everybody's just working on those particular wordings. How does this mean? What does this mean? What does a court of law mean? Is it a court of plenary jurisdiction? Is it a constitutional court? Yes, those are necessarily important questions. But in the context, in the order of priority, I would put it at number 10, probably, if there are 9 other more important ones. Sorry, I went on a bit too long, but can you focus on those aspects?
My Lord, that was by the court of law. In a way, your Lordship's observations connect and resonate with the question posed by my Lord Mr. Justice Sayyid Mansoor Ali Shah. My Lord, how the qualifications and disqualifications envisaged by the original constitution makers make perfect sense. That if you could disconnect them at a time, they make perfect sense because they deal with 2 different subjects. In 1985, at the presidential order of 14th of 1985, which we call the revival of constitutional order,
declaratory jurisdiction exercise.
All these changes came about with a minor change again through the 18th Amendment. At that time, when a whole host of disqualifications and qualifications were added. And when these were added at that time, virtually we lost the plot. And it would be difficult to say that 62 and 63 are now disconnected provisions. They are connected, they have to be read as a whole. Now, insofar as those amendments were concerned, they virtually were envisaging, as observed by one of your lordships in an earlier 7-member bench judgment, virtually a society of angels and parliamentarians who were probably even holier than angels to come into parliament. So there was a disconnect with real life, which reminds one of your lordship's observations, remind one of the quotes of Abraham Lincoln, that it has been my experience that folks who have no vices have very few virtues. So virtually introducing a society of people with no vices and few virtues, but
may be subject to correction.
In these qualifications and disqualifications, these very long lists, there is a connection. And the connection is that you cannot read Article 62 without looking at Article 63. And even earlier, you could not read Article 62 and 63 without being conscious of the rights of citizens under Article 17 of the Constitution. This court has always been mindful not to disenfranchise people, that the right of people to form and join political parties is there, and a person has a right to contest elections. 62 and 63 both make inroads to an extent under that fundamental right. The inroads were sensible inroads when it came to the original 1973 Constitution, that we will not allow an insane person to be a member of the Parliament, that we will not allow an undischarged insolvent to be a member of Parliament, we will not allow a person who is not the citizen of Pakistan or is the citizen of another country to be a member of Parliament, that we require that persons should be at least 25 or 30 years of age, being National Assembly or Senate respectively, to be members of Parliament.
Constitutional petitions,
and none of those make an inroad into Article 17 of the Constitution.
So it's an extra jurisdiction conferred by the Superior. And then something has also been said that ordinary legislation is not a substitute for a constitutional amendment. Okay, you bring in a constitutional amendment, we strike it down by the Constitution. So our wisdom is paramount. So we can do whatever we want to, not guided by anything other than our own under the Constitution, which is ideas of morality. Appellate jurisdiction.
And that is the submission that two things you will not find. You will not find
jurisdiction onto the
judgment from the common law jurisdiction where
jurisdiction on the
by
Supreme
declaration
Court.
of the court, because this is not a declaration of Parliament, my lord. Article 63
and you concede that I mean, this is no disrespect to anyone. We cannot. Will you concede that the parliamentarians in Pakistan are the best in the world? The words court of law, which are the best in the world. It surely not. Otherwise, this power should have been mentioned in Article 184.3.
No.
Does any other country, a single country in the world, have this test for parliamentarians? To say,
not that I am aware
we cannot
of.
just disregard. If we have this test, and we don't have the best parliamentarians in the world, a civil court under Section 9, it's not even a workable law. If assumed anything else, I mean, it's just words on a piece of paper which I can use for my personal
court of law is not defined.
projects, I would say.
Because I've just read one article. Supreme Court and High Court.
Tomorrow you are honest, you can be declared dishonest. Out, in, it's up to me. I can just write some few words of English language and that's that.
To give an immediate example, the US Supreme Court has a similar requirement.
As opposed to extraordinary constitutional jurisdiction.
No, my lord.
You can physically, you can check this. Yes.
Like we had in the 73 Constitution. Even when the US Congress sought to introduce new qualifications of this kind at a particular period of time, in Powell versus McCormick, the US Supreme Court struck it down. They said no. The Constitution has given a list of qualifications. Congress cannot add to that list of qualifications. That's where we stop. So the courts in other places have gone the other way. They've said, here is the
speaking for myself, we'll have to, expounding the Constitution, we have to
under the law.
Rely on the tools of interpretation. I look at the Constitution post 18th Amendment. I think the dictator argument is out of the window because it is the 18th Amendment passed by the Parliament. So I need to give it a very serious thought in interpreting the Constitution. So every word to me is important. I could just disregard all the words and say this is not the Constitution. That cannot happen, even though I might disagree with the wording of it. But some meaning has to be attributed to it. I find the declaration personally making no sense, but I have to give it a meaning because I can't throw it out of the Constitution. I don't have the jurisdiction to do that. So having said that, you were at that moment explaining that the court of law would have criminal and civil both. Could you just resume from there in the declaration from a court of law under 62(1)(f)? Court of law is only the court of
a side
law
query
under
with
plenary
what my
jurisdiction,
lord is
plus
observe.
the election tribunal, and as a consequence, the appellate forum that hears the election tribunal. These are the plenary jurisdiction plus these two, which can give such a declaration. There can be no declaration coming from the High Court.
I would reframe it. There would be redundancy to the interpretation of the Constitution by this court, which is not quite the same thing. The Constitution does not say that you stand disqualified. We say you stand disqualified. My lord, if the Constitution had simply said so, end of story, fine, that argument would be. But it is how we interpreted the Constitution has said so. Because I don't know if that's my point or not.
May I as counsel mediate a safer course for myself by saying
please, we never mind anything. We're going to first election act. We bounce ideas, we are thinking clarify.
Take the Haal response.
Election act section. Be as critical as you want.
My lord, the safer course which I suggest for myself is that when your lordship looks at the Constitution,
it says duties of commission.
Whether your lordship looks at it, my lord the Chief Justice is looking at it, or my lord, your lordship Sayyid Mansoor Ali Shah Sahab is looking at it, there is no redundancy.
We come to the point.
It is redundancy is created by Samuel Baloch. If your lordships read the Constitution the way Samuel Baloch reads it, there is redundancy. If your lordship reads the Constitution, the legislature intended it after the 18th Amendment, there is no redundancy. Because if a court of law includes a court of criminal jurisdiction, then it immediately takes your lordship to the provisions of Article 63(1)(g) and H, and there the limits are specified. Their lordships then make a further distinction, and that's again Samuel Baloch, that a person who has been convicted has then paid his debt to society, forever suffers the odium of being a convicted criminal, and therefore he is in a different league than from a person who suffers a civil liability. Parliament doesn't make that distinction. The court does. It is the interpretation of the court which is making the Constitution redundant. My lord, that logic also does not hold. Why it does not hold? My lord, in criminal law, and my knowledge of criminal law is very, very peripheral, and your lordship will excuse me for that, but I make a distinction always between conviction and sentence. A person serves out a sentence. A person never serves out a conviction. The conviction remains on his record forever and ever. If he has served even till the rising of the court.
So how is the Supreme Court another matter which is pending adjudication in this court? I am of the view, and others of a different view, and I requested for a larger bench to be constituted, and I may be feeling my duty is not to have done so myself, and so much has been happening, we're working morning to night, was that in a murder case, 345 allows compounding of an offense, which you're mixing up. There are two views in this court prevailing. One view is it brings the sentence part to an end, it does not efface the conviction. The other view is it effaces the conviction, for instance, and the sentence both. In a civil suit, even civil court has jurisdiction to debt to society part. Suppose this person commits murder, right? Or and next day reject the claim, secures a settlement with the legal heirs. Where is the debt to society has been paid? That it hasn't been paid. He will file nomination papers on it. Have you been convicted of an offence? Answer would be no. Filing a frivolous if that interpretation of the Constitution is followed, which says that it effaces the conviction and the sentence. That honestly answer as well. Whereas if the interpretation which I have favor is holds, he will say yes. sentence part would be a different part. So even though he didn't pay debt to society, did not serve 1 day in jail, he still can contest elections in that scenario. So this debt to society argument, I also find a bit fallacious.
I guess let's wait for a larger bench on that question. That will take us yet to another argument altogether.
For the debt to society argument,
already there from the written
debt to society argument in the Samula Baloch case, when your lordship looks at 63,
Mr. Mazaaq, I mean, taking up that argument that you said, court of law would be both. So when it's criminal, then of course 63 gets retracted, but when it is civil, 63 doesn't get retracted, it stays where it is, and we have to deal with it. So there is a declaration which is civil, arising out of original jurisdiction, the way we're looking at it, and it's calling somebody a fraudster. Now the question is, how do we put a time frame on it? There's a decree standing in your face saying that you're a fraudster. Now what do we do with it? How do we treat that degree and think of it that it has a time bound or it doesn't? Because inter-party it probably stays forever. But for elections, should we take a different?
Let's come to the time bound question. Time bound supporting Samula Baloch.
To some extent, I am because in most of the cases
started from the day when the decree was passed or from the day when the elections are called.
in some
because
cases,
also that there is no dispute to the fact that inter-parties that stays forever.
Inter-parties?
That stays forever.
Inter-parties that stays
unless it's set aside, of course.
That's true.
But for elections, perhaps a different treatment needs to be given.
And my lord,
how do we do that?
For the reason is, Parliament over here, even in the 18th Amendment, doesn't say that the declaration will remain forever.
Right.